Hi, welcome to this week's discussion on the criminal trial. Why is everyone so fascinated with the criminal trial? Well, we get a lot of celebrated cases. Most of you are probably not alive for the O.J. Simpson trial, but I remember it because I was in high school when that was going on, and it dominated uh, not only local channels as it was broadcast in its entirety, but any news program, any newspaper, um, it was the topic of conversation pretty much everywhere, and it seemed everyone had an opinion on it. But what's interesting about these cases is they're not your typical cases. These are very out of the ordinary cases. They account for, you know, less than 1% of all the cases that are filed. And these cases are most likely to involve, serious conflict, not only with the facts and the evidence, but with public opinion. And what these cases really do is they really highlight the adversarial nature of our system. There are 10 parts to the criminal trial, beginning one with jury selection, followed by opening statements, then presentation of the prosecution's case, then the defense gets to present their case, and I would actually switch jury instructions with closing argument. Then you would have jury instructions, then closing argument, then jury deliberation, verdict on the guilt, and if the defendant's found guilty, then you move on to the sentencing phase and then pronouncement of the sentence. Let's start first with opening statements. Opening statements are after the jury is picked, and it's the first thing that the jury hears once they are impaneled. It is really just a preview. I like to think of opening statements as, those of you that read, you get the synopsis on the back of the book that tells you what it's about. It's that's an opening statement with a little more detail, and it always spoils the ending. The prosecution will say, we expect, after you've heard all the evidence, that you find the defendant guilty, and the defense will say, we expect that after you've heard all the evidence, we expect you to acquit our client and find him innocent of the charges. Okay? So opening statements can go one of two ways. The prosecution can present theirs, and then the defense can go immediately following, or the defense can wait until after the prosecution has closed their case, and then they can present their opening statement after the prosecution rests. Now, there's varying opinions on which one is better. I mean, it's really a tactical decision on the defense attorney's part on how they want to do it. If they present their opening statement after the prosecution presents theirs, then the jury has at least an idea of what both sides of the story are. Now, some defense attorneys like to kind of keep things a surprise because the prosecution doesn't know what the defense's case is going to be, because discovery is very one-sided. The prosecution has to turn over all of their evidence, but the defense doesn't have to turn over any of theirs. So some defense attorneys like to keep what they're going to do or what their defense is very, very close, and they like to keep it a surprise. So they like to wait until they're ready to present their defense. Surprise can have an effect on the prosecutor's case, but they also run the risk of the jurors making up their mind with the prosecution's case and not really listening to their evidence. So I'm not sure which is preferred, or I'm not actually sure which is preferential. I think it depends on the case, the facts of the case, the individual jurors you select. I personally wouldn't want to wait. If I were the defense attorney, I would go after the prosecution so that they always have that in the back of their mind during the prosecution's case. Well, I think the defense is going to be able to present this. or I think they'll negate it with that. But in any case, it is a preference and it's a tactic. And so opening statements in and of themselves really are just to give the jury an idea of what is going to happen. Both parties will say, we expect the evidence to show. There is no arguing an opening statement. All it is what they expect the evidence to show and what facts they hope to lay out. They cannot argue or surmise or try and persuade. Really, what they do is paint a story. And the really great opening statements are more like an oratory, where the juror can picture in their mind what happened, just like a good novel will do to you. Okay, after opening statements, you have the presentation of the evidence. So presentation of the evidence begins with the prosecution's case in chief. That means the prosecution has to prove each and every element beyond a reasonable doubt. Okay, and it's going to call, okay, and what does that mean? Well, you're going to have the prosecution's witnesses. They are going to testify. And sometimes there will be physical evidence, such as photographs, a murder weapon, ballistics, drug evidence, whatever the case is. But the majority of evidence that will be presented will be testimonial evidence. Now, after the prosecution has presented their case in chief, the defense attorney will call for a motion for directed verdict or acquittal, meaning that they'll say, hey, judge, we don't think the prosecution has proved each and every element of their case. And if the judge agrees, the judge can grant the motion for directed verdict, which is a verdict of not guilty. Okay, and that's only if the prosecution has failed to prove each and every element of the case. Okay, if it's granted, that means the trial's over and the defendant's released. It's very, very rare that that happens. When I was a defense attorney, I only had that granted for me one time. It's something that the defense will ask for each and every trial, but it's rarely granted. And most of the time, the judge will allow the prosecution to reopen the case. And the prosecution will say, judge, okay, we just permission to reopen. And the judge will typically allow them to recall a witness to get whatever element they left out. So a common one is they forgot to prove that it occurred in, if this is here, they'll forget to say, did the crime take place in El Paso County, Texas? And that's one that gets left out a lot. Defense's case in chief. Now, the defense is not required to present anything. In fact, they don't have to do anything ever. They can sit there, not question a witness, not make an objection, not do anything. Why is that? Because the defense does not have a burden at all. The burden is on the state to show that the defendant is guilty beyond a reasonable doubt. The defense does not have to do anything. Now, most defense attorneys are never going to do that. They are obviously going to present a defense. Okay, and so what they do is they call their witnesses. And the witnesses are questioned by both sides. Okay, and so even in the prosecution's case, when a witness is called, that whoever calls the witness, that is their witness. So in this case, since we're talking about the defense calls defense witness number one. The defense will ask direct questions, okay? And we call this the direct examination. Direct examination is when one party questions their own witness. Now, for those kinds of questions, they have to use open-ended questions. So, would you please state your name for the jury? Okay, that's just instructional. But can you please tell us what happened on the night of, November 1st of 2017? Where were you? What were you doing? Who were you with? Now, when the defense finishes their witness, it will be the prosecution's turn, and the prosecution will then cross-examine the witness, and they will do so using leading questions. Leading questions are those questions that assume the answer. So, Mr. Defense Witness, you weren't actually there that night, were you? In fact, you were at your brother's house, correct? And we know this because there's a photograph of your brother that he of you and your brother that he posted on Facebook on the night of whatever it is, and you just ask questions in that leading manner. That is how you cross-examine a witness. Okay, so after the defense's case in chief, let's talk about calling witnesses. I guess I got ahead of myself. All right, the Sixth Amendment gives the defendant the right to confront the accuser and any witness against him. So that is what cross-examination is. Witnesses are brought to the stand by subpoena. So both sides have the power to subpoena a witness and demand that that witness testify. If the witness doesn't want to testify, the judge can issue an order for arrest if they ignore the subpoena, and they can be brought to court. If they refuse to testify, the judge can put them in jail until they decide to cooperate because they are under subpoena. Now, there are some witnesses that you can't call and ask. I mean, you can call them, but they can't testify as to conversations that occurred because they are privileged communications. Those are between priest and parishioners, husbands and wives, lawyer-client. Now, there isn't a doctor-patient privilege because that's actually a special exception for one of the hearsay exceptions. Whatever someone tells a doctor for medical attention, that's actually one way that you can get hearsay testimony in. Okay, and another thing that you have to deal with witnesses is the privilege against self-incrimination. That's our Fifth Amendment, the I take the Fifth, where a person does not have to testify and they cannot be made to testify against themselves. Let's talk about evidence. There's a couple different ways to break down evidence. You have real evidence versus testimonial evidence. Real evidence is something that's tangible. Okay, something like DNA, fingerprints, the weapon, a gun, a bloody shirt, drugs. Testimonial evidence is sworn witness testimony. A person takes the stand and says, yes, I swear to tell the truth, the whole truth, and nothing but the truth. Okay, that is testimonial evidence. And both can be considered by the jury. And really, the jury evaluates all of it. Just like they evaluate physical evidence, is this something that we actually believe came from the scene? Has it been tampered with in any way? They do the same with testimonial evidence, except they're judging the character of the witness and whether or not they feel the witness is telling the truth or is maybe biased. Another way to differentiate evidence is by direct or indirect. Now, direct evidence proves or disproves a fact. Indirect evidence is circumstantial evidence, and it has to be interpretive. So direct evidence typically is a witness saying, I saw the defendant rob the 7-Eleven. Indirect evidence would be something like fingerprints on a weapon found in the car and the weapon ID'd by the clerk. Okay, it's got to be interpreted. So that's the difference between indirect and direct. Let's talk about the rules of evidence. Not all kinds of evidence get to come in. There are rules for introducing evidence. First and foremost, evidence has to be relevant, meaning it has to be able to help the jury decide whether or not the defendant is guilty or not. Another thing is whether or not a witness is competent to testify. A witness has to be able to, if they're a fact witness, they have to be able to show that they actually saw or heard something that's relevant to helping the jury decide. And it can't be hearsay. Hearsay is anything that was said outside of court. Now, are there exceptions to hearsay? Yes, there are. Whatever the defendant says is non-hearsay. So any witness can come in and say, I heard the defendant planning to rob. What the victim tells the doctor in the ER, that's non-hearsay. There are objections to evidence. One side or another can object, and then the judge decides. And the judge will decide based on which side is following the law. There are numerous objections, but the most common ones are objection relevance, objection competence, that witness shouldn't be allowed to testify, objection hearsay. Another one is objection more prejudicial than probative, meaning that the evidence is more likely to upset the jury than to help them decide. A common example of more prejudicial than probative would be autopsy photos. 9 times out of 10, they don't help the jury. They're more likely going to play on the jury's emotions rather than help them decide the case. Now, sometimes they're helpful, like when there's multiple bullet paths and things like that, but most judges do not let those in. Restricting the introduction of evidence. There was a handful of laws that were passed in the feds and in multiple states regarding evidence on a rape victim's sexual history, and those are called rape shield laws. Before the rape shield laws, victims' sexual history used to be admitted, and the case became not about what the defendant was accused of, but about the promiscuity of a victim. Thankfully, we had laws enacted that limit the admissibility of the sexual history of the victim. So after these rape shield laws, for the most part, the victim's sexual history does not come into evidence. Now, if the victim and the defendant had a prior relationship, that is something that can be brought up. But for the most part, the defense is not allowed to bring up the victim's sexual history. All right, so what happens after both sides rest and close, meaning they are done presenting evidence? Well, we get instructions to the jury. The judge is going to give instructions that talk about the law. Some of the most important ones are the presumption of innocence, and that's that the jury is to presume that the defendant is innocent until the government proves him guilty beyond a reasonable doubt. Okay, so what is beyond a reasonable doubt? It's not beyond all doubt. It's not beyond all possible doubt. It's a reasonable doubt. Now, beyond a reasonable doubt is more than probable cause. It's more than what it takes to arrest someone. It's more than what it takes in a civil trial, which is it more? In a civil case, one side has to prove their case by a preponderance of the evidence. That means that if you took the plaintiff's evidence and put it on one side of the scale and the defense's evidence on the other side of the scale, whichever way it tipped, greater than 50%, that's who would win between a plaintiff and a defendant in a civil case. Next level, you would have clear and convincing evidence. That means that the evidence has to be very clear and it has to be convincing. This is used in like CPS cases when they are trying to terminate parental rights in an abuse or neglect situation. Now, beyond a reasonable doubt requires more evidence than that. But again, it's not beyond all doubt. And it has to be reasonable. Okay, and that means something different to everyone. The courts no longer allow a definition of beyond a reasonable doubt. That is something that each and every individual juror has to decide for himself or herself. Okay. In the instructions, the judge is also going to define the elements of a crime. And the jurors are going to have to determine if each and every element has been proven beyond a reasonable doubt. And it's going to explain any defenses. So is there self-defense, defense of others, anything else that's a justification for the offense. So what does the research on juries say? Oftentimes the juries don't understand the instructions. You'll usually have a couple that will understand it, and one of those people usually ends up being your foreperson and kind of leading everything. The language used in these instructions matter. The attorneys on both sides will often argue over the jury instructions, and they'll argue over small phrases that you probably wouldn't think are important, but they can actually be very important when it comes to proving someone guilty or not guilty, because the jurors do look at them. So it's best to have very clean, non-technical instruction. Typically you shoot for about a 6th grade reading level. So after jury instructions are given to the jurors, and hopefully each of them have their own copy so they can follow along as it's being read to them, then you will have closing arguments. The prosecution goes first, then the defense, and then the prosecution, because they have the burden of proof, gets to go again and offer a rebuttal to what the defense said. Now, closing arguments are different than opening statements because you get to argue. And the prosecution, and both sides are able to argue in 4 areas. They can talk about anything that's going to persuade the jury based on the evidence at trial, but they have to limit it to what was heard at trial. They can summarize the evidence. They can argue logical deductions from the evidence. So, defendant's prints are on the scene. Prints are on the murder weapon. There was blood on the defendant's shoe that matches the blood of the victim. Those are all circumstantial evidence that can be used to tie the defendant to the crime. Okay. The prosecution can also do a plea of law enforcement. Ladies and gentlemen of the jury, send a message to the defendant that his behavior will not be tolerated. Send a message to the community that we as a community will not accept this behavior and that we will punish it. The defense will do a plea for presumption of the innocence. Ladies and gentlemen of the jury, the Constitution of the United States requires that you presume that my client is innocent unless the state proves him guilty beyond a reasonable doubt, and they haven't done that. And then they'll talk about what reasonable doubt there is. Okay, but one thing's important. Neither attorney can violate the golden rule. They can't ask the jurors, imagine if you were the victim. Put yourself in the defendant's shoes. They can't do anything like that. Okay, so after both sides have closed, the case goes to the jury for deliberations and verdict. So the jurors go back there, and unfortunately, we don't know really what they talk about. If you haven't seen 12 Angry Men, that's the picture on your right. Watch it. It's a really great movie about, what happens in a jury room, because we don't know. Only the jurors are allowed to be there. When they come out, that we can ask them questions, and they often do try and interpret and apply the law. They talk about witness credibility. Was this person believable or not? And if not, why not? They hopefully try to ignore bias. We assume that they do, but people are human beings, and laws can sometimes be ambiguous and open to interpretation. Sometimes there's a lack of evidence, and sometimes jurors consider things that are irrelevant, like, did you see how she was dressed? We didn't like it. I had a case one time where one of the main defense witnesses flashed a gang sign as soon as she got on the stand to the defendant, and 2 of the jurors caught it, and they, from that point on, decided all the defense was lying. So you just never know what it's going to turn on. In the news lately, there's been a lot of cases that have been overturned based on DNA exonerations, and they have innocence projects throughout the country. Most of the innocence projects are sponsored by law schools, and law students work on these appeals to get cases overturned, that were based on witness misidentification, cross-race identification, which happens quite often. Cases where there was bias or prejudice that played in to the conviction rather than actual evidence. Let's talk about the requirements of unanimity. Okay, really the jurors should speak as one, and they really should agree. And in 2020, SCOTUS required unanimous decisions. Prior to that, Oregon and Louisiana were the only ones that where you could have not unanimous decisions, I think 10 out of 12, but that changed with the SCOTUS decision in 2020. Jury nullification is a real thing. Okay, most trials will end in a conviction unless there's reasonable doubt, but sometimes the guilt is overwhelming, but jurors still find the defendant not guilty because they will nullify it, and they acquit either because they don't like the victim, they think the defendant's a good guy. Maybe it's a vigilante justice. They don't like the law. Whatever it is, nullification happens. Sometimes jurors just can't agree. So what happens? Well, you have a hung jury. That means it's a failure to achieve a unanimous jury. Sorry, that should say unanimous, not anonymous. Ignore that. Okay, that means they're deadlocked. I had a jury one time that were throwing things at each other. Judge had to call that a hung jury and declare a mistrial, and we ended up not even trying that case again. Sometimes this happens when it's a real complex case, when the evidence is ambiguous, or sometimes jurors just can't get along. So how does the verdict get announced? Well, the foreperson gives the verdict to the bailiff. It's read by the judge. And sometimes the judge will ask, actually, usually all the time, the judge will ask, would either side like the jury polled? We'll say yes. The attorneys will say yes. And juror 1, is this your decision? Yes or no? And go through all 12 or 6 jurors. Judge cannot overrule this. Well, they can, but if the judge enters another verdict, notwithstanding the jury verdict, obviously it's going to result in an appeal one way or the other, but typically the judge just allows the verdict to stand. After the verdict, if it's a not guilty, the defendant is released. He can never be tried for that crime again. If the verdict is guilty, he has a right to appeal. Typically, the defense will file a motion for new trial within 30 days of the verdict. If it's granted, they'll have a new trial. Most likely than not, it'll be denied, and they'll file for a motion to appeal.